All lectures thus far have had as one focus that the doings of the law and of judges should never be taken on trust, not because they are inherently untrustworthy, but rather because the citizen has to be wary not to trust the law and lawyers too much. The law is, or has become, something of a religion to which international bodies representing the citizen now turn in need, treating lawyers and judges as priests and oracles, able to provide not just judgments from argument, but also to provide the truth. Does the law merit this respect? Can it go further than it normally reaches by performing its basic job, especially when dealing with conflicts, international or national, on a large scale? Hannah Arendt, in her book on Eichmann and the Holocaust, said that even the noblest ulterior motive of a court like that, the supposed higher aims of the Nuremberg trials, can only detract from the law's main business to weigh the charges brought against the accused, to render judgment, and to mete out punishment. Even assuming her narrow view of the function of the law is right, it's not that easy, even with the best will in the world, to confine its output or effect in the way she might have preferred. It is all too tempting for the citizen casually to allow law's wider potential to do things beyond its proper scope. In this lecture, I consider the potential of the trial process and of trials in war crime courts to go further than just to deal with individual criminal responsibility for actions and to write or rewrite history for parties to the conflict. It may always be helpful to compare aspects of what is new and untested, as the war crimes trials of the last 20 years are, with aspects of what is familiar, tried and well-tested, the domestic national criminal trial. Such trials are immensely significant to the individual who is found guilty or not guilty, who is punished or not punished. Some trials may be of a higher significance in that they reveal something about societies and the nations in which the trials take place. The Dreyfus trial and the trials that were part of it revealed much about French society, corruption, anti-Semitism. It became part of French history, but remained effectively the case of a single man. The trials of Oscar Wilde, revealing as they were of their time, are not substantially usable as instruments of deception about history, only of revelation. The Oz trial that some of you will remember here in this country showed a great deal about current standards of morality and the seeming corruption of the legal process given the conduct of judges in that case. But it didn't rewrite or even write history. The same could be said of the trials of IRA offenders who revealed a corrupt police force and the need to change procedures. Of course, occasionally a trial can have a real effect on the history of a nation. A tiny little example: the trial of Penn and Mead in 1670 at the Old Bailey, or thereabouts, revealed that judges cannot browbeat and threaten juries to bring in guilty verdicts if juries want to say not guilty. And as a result of that trial, the fabric of the law in this land changed. It actually had an effect. The trial had an effect on history. But that's very much the exception. And international and war crimes trials, it seems to me, are very different in the potential effect they may have. To make good my argument, where should I start? Well, Professor James Gow of King's College London, building on an idea actually that was provided to him by a colleague of mine, Gavin Ruxton, from the Yugoslav Tribunal, suggests that the very first international war crimes trial was that of William Wallace. International because it concerned England against Scotland, a trial because he was dragged down to London and into Westminster Hall, where the indictment was read over to him. He wasn't actually allowed to speak, but it was nevertheless read over to him. He wasn't therefore able to deny the treachery charge, which was always problematic. He was then taken out and subjected to the most appalling execution immediately. He was without representation throughout the event. Why bother with a trial at all? The court of noblemen acting under the king's direction no doubt reflected the sovereign's understanding that a statement of Wallace's crimes in the form of a trial, reinforced by an unspeakably barbaric death, would reinforce the accuracy of the victor's view of history, maybe better guarantee the peace. That's also apparently Wallace on trial, a romanticized image. Here's another image, a little later. Peter von Hagenbach, 1474, is more commonly identified, the trial of this man, as the source or a source for the legitimacy of modern international humanitarian law. It can even be seen as the trial in which the origins of crimes against humanity may be found, and as the first example of a trial where rape was charged and where the defense of superior orders was rejected. Hagenbach was tried in Breisach for atrocities committed in his service to the Duke of Burgundy before an ad hoc tribunal of 28 judges from regional city-states for murders and rapes that he committed, apparently, as governor of the Alsace territories. Now, interestingly, even now, people argue over what he was really doing. Revisionists say, in fact, far from the bad man he was said to be, he wasn't all that bad, and he was something of a modernizer. But he was convicted, following a trial, publicly beheaded. And again, why bother with a trial at all in these days? Scholars say, oh, well, there was a trial because the Holy Roman Empire was falling to bits and we hadn't yet reached the stage of the Westphalian sovereignties, so there was a convenient moment for a trial. Maybe. They say, well, there was no opportunity for this kind of trial until it was attempted after the First World War with the Kaiser. It didn't come to anything, but it was set out there as a possibility in the Versailles Treaty and finally came into effect at Nuremberg. But why bother with a trial in 1474? Well, as the scholar who some of my work here is dependent on, Gregory Gordon from North Dakota, suggests there was a practical political need to cast history in such a light as to see off Charles the Bold, that is, Hagenbach's boss. And that may have been the reason for having a trial, because otherwise, just as with Wallace and as with the next candidate for you to consider, you could just cut his head off. You didn't need to have a trial. Why bother? Well, let me come back to that. I haven't got a picture of the next one, because you all know about it. It's Charles I. Charles I, in a very interesting trial here in London. Why bother to try him? They didn't even bother to depose him. They tried him as a king. They tried him, of course, as you know, in Westminster Hall, same place as Wallace, and much can be said about the trial. They had no legal authority. It was created by the power of the army. The king wasn't given advance notice of the charge. He had no one there to defend him. The court did not pretend to be impartial. His refusal to enter a plea was taken to be a plea of guilty, not a plea of not guilty, and so it went on until such time as we all know, he was taken outside and beheaded. The justice, it is said, was not competent, independent, and impartial, nor was it established by law. This was a revolutionary court, summoned to perform a revolutionary trial in wholly exceptional circumstances. Expressed differently, no, I didn't put that one up either, the trial and execution was part of a dramaturgy, a drama of state, designed to convince its audience that the text of King Charles' life must be read as reason and his death as exemplary and condign punishment. By staging the trial as a public display, the regicides strove to justify, but also they exposed to open challenge the legitimacy of their cause. So they may be seen as having made efforts to give the semblance of justice. The fact was that they felt an obligation to trial at all is noteworthy because it's a reflection of the power of a trial. It's a reflection of the effect that a trial can have on society, both in writing the history of society and maybe in some ways preserving the peace, whatever the peace may be that you have by then achieved. These trials, and the last one to come, were not legal processes reflecting the rights of accused persons and victims. They were reflections of the exercise or use of power, and not necessarily the abuse of power. In each case, given the possibility of summary execution, a trial process was used for objectives and included or may have had as a principal component writing of a history. In these cases, we see the understanding of the power or use of trials, a power that you may find you can recognize even today. Let's finally get through to the slide I keep showing you. Right. A number of nationalities. I can't ask you publicly to do anything politically incorrect, can I? So look at them and think about them, and ask yourself of those various nationalities whether in this politically incorrect moment of private thought you regard some of these nations as more likely to commit terrible crimes, domestic or national, international, than others. Now, if any of you have identified some of the nations that qualify for that description, ask yourself why you think that. Is it because of what you were taught at school, what you read in the newspapers, what you see on television, because of personal encounters, or may it be because the trials that have happened of these people reinforce a view you have of them? And if that possibility appeals to you, this, of course, is the best possible example. We all know what this picture and this picture are of. Does consideration of these accused standing trial at Nuremberg, whatever the shortcomings of the overall legal process that excuse the Allies altogether, despite their wrongs, the wrongs that they may have done by modern standards, does the fact that it was only them on trial, and they were tried, reinforce your view? Does the fact, and there's the paper, I think, announcing the hangings in Germany, but does the fact that these three men, and after Roosevelt's death, these three men, were never even considered for the process of investigation of what was done being a crime, make it very difficult for us to look back and to even allow for the possibility that the history was other than completely black and white? And if those trials, the images I've shown you, has that effect, does that rather reinforce the proposition I'm developing about the potential for war crimes trials to do a great deal more than just to try the individual? And if, for example, you were to, from that collection of nations I showed you, to have allowed your mind to pick upon the Germans, why? There's nothing different between the Germans and us. We're all North Europeans. Was there plenty of anti-Semitism around in Europe before the Second World War? What is it, apart from the events, and perhaps that event? And I'll just tell you this, by way of anecdote, before we get to the bit more substance. I occasionally spend time in the polite society of judges, and by and large, I think, modern judges genuinely believe in the standards that lie behind equality providing acts of Parliament. They genuinely believe it. And yet, in private, you can occasionally hear them make the most terrible assertions about nations and individuals from nations. Why? Well, it may be, of course, that they happen to have had experience of that nationality appearing more often than might be expected in their court. And that blurs their judgment, because they don't actually step back and say, well, it may be I'm seeing a bit more of this particular nation, but that has to do with the recent history of the nation, its emergence perhaps from the communist yoke, or whatever else it might be. So, let's go back to international trials. has the potential to try all sides of conflict, something I dealt with in an earlier lecture. Has the codification of the rights of the accused and of victims in modern international trials changed or limited the way trials may shape history? Is it reasonable to expect modern states to act differently from the way in which states acted from medieval times onwards, using trials for a political purpose? Well, before we come to that, an aside. The judges of all these courts, the Yugoslav court, the International Criminal Court, will always say that they do not write history in their judgments, and they don't, and they mean it. This was noted, for example, in one judgment in a case called Kupreskic, where it said the primary task of this trial chamber was not to construct a historical record of modern human horrors in Bosnia-Herzegovina. The principal duty of our trial chamber was simply to decide whether the 6 defendants standing trial were guilty of partaking in this persecutorial violence. So a hark back to Hannah Arendt in her book on the Eichmann trial. Another Yugoslavian tribunal quotation comes from the much respected American judge Patricia Wald, and it's worth reading a little bit. Initially, the tribunal was urged to make detailed findings about the social and political etiology of events leading up to the atrocities on trial. This, it was suggested, would provide an antidote to revisionist history by preserving adjudicated accounts of what actually happened in the foreplay to the Bosnian conflicts. As a result, dozens of pages of judgments focus on the causes and precursors of the 1991 outbreak of hostilities. However, commentators, citizens, and officers of the implicated countries increasingly suggest that the adversarial trial process and the findings of judges may not produce the best approximations of history. Moreover, the adjudication by the Yugoslav tribunal of who started, prolonged, or ended the war and why, in the context of criminal proceedings, without the states themselves having input, is basically unfair, or at least doesn't contribute to future reconciliation. So here the judges themselves say, beware, we don't write history, and there's something inherently unfair in the supposition that we do. Rwanda, the conflict in Rwanda, and other African conflicts discussed in my last lecture showed how these modern international courts can be engaged in a cynical way to become instruments of conflict, which is in itself part of the business of writing history. If one side of a conflict gets the court to prosecute the other side, the Hutus, but never the Tutsis, for example, then writing a balanced history of that conflict is much more difficult. Coming to the Yugoslavian conflicts, what lessons may we learn from consideration of this issue in the context of that court, which was probably the most successful of the modern international courts? The statute and rules of the ICTY, I'm not going to ask you to read them, but I think they're there and there, operate in all ways to oblige states to cooperate with the tribunal in the surrender of individuals and the provision of documents, and then to go on to provide a regime to the rules whereby a state in conflict, Serbia, Croatia, Montenegro, but also the same, I dare say, under the ICC for other countries, the state in conflict is accorded as much privilege in holding documents back as would be, say, France or Norway or Canada. The consequence of this has been pretty dramatic. But how could it ever have been realistic of those who established court systems stuck in a remote northern European country with no police force and limited powers of securing documents from states that had been at war, to rely on the goodwill of those states to help in the production of documents to prove cases against their own nationals? It was about as realistic as expecting a bank voluntarily to provide incriminating emails about LIBOR fixing to be used against its own executives if it had even the remotest chance of putting off provision of the documents for 3, 4, 5 years and creating a few more on the side, which is what happens in war crimes courts, as we will discover. The Yugoslav Tribunal's rules allowed in principle for every conceivable tactic to be taken by Serbia, for example, but also by other third-party countries, to handing over what might have been interesting. And concerning was that the judges didn't seem that keen to cut the red tape and to make the process swifter. Many would argue that from the very start of the Yugoslav Tribunal, Serbia knew that it had to take it seriously, not in order just to assist in the prosecution of serious individual offenders, but in order to do what it could to preserve Serbia's long-term reputation to the extent possible. Now, Serbs have been assessed by almost all independent observers as having committed the most serious of crimes in conflicts where some 6 states and entities were involved. And Serbia may well have wanted to create, wherever possible, some kind of moral equivalence with those other parties to the conflict, and in this way to rewrite its history and the history of others, and in particular the histories of Bosnia and Kosovo. Serbia proclaimed a policy of cooperation with the tribunal in the extradition of indictees such as Milosevic and others. It had an entirely different approach to allowing the tribunal to have access to documents from the federal and Republican state archives. The prosecution that I had worked for at the time requested many documents on many occasions between 2001 and 2004, always to be met with by Serbia using procedure to block production of helpful evidence. Belgrade's position on the fate of Kosovo-related documents varied from denial that the documents existed at all to claims that they'd been destroyed during NATO bombings, or to assertions that they simply couldn't be located. Where documents were eventually provided, it was found that they'd been selected in a way that was not responsive to the request we made, and quite likely the documents produced were favourable to the defendants. This assessment of the cooperation by the prosecution prompted the following answer by a lawyer representing the Serbian government, the important part of which really is highlighted. He says, relying on the procedure to avoid providing evidence, he says, "In this, the government is indeed an adverse party to litigation, as any other government would be and has been in a similar procedure." What nonsense, you may think, as the world citizen. If you want serious crimes committed in conflict to be brought to light, and this body, this state, holds the document, why should it be in a position to be an adverse party to litigation, in the way that parties are adverse to litigation in criminal courts and so on? Why is it not genuinely opening its doors and saying, time has come? Well, it's not doing it because that's what states don't do. States given a chance to control some process that affects their benefit, their future, their history, will always stick to it. When rejecting the notion of non-cooperation, the Serbian legal representative reminded the court that Serbia was following the court's orders, and the court's excessive respect for Serbia allowed them to assert this. For example, there's something called war diaries, immensely valuable. We asked for them and were told, oh, there are too many. You can't ask for that many. Why not? This is a conflict where thousands of people were killed. They were all sitting on a shelf. We weren't allowed them because we said we'd asked for too many. Happily, once and once only, the court had the courage and said to Serbia, produce that document overnight, and they had to. And it contained cleansing village, an admission of ethnic cleansing in writing by a contemporaneous document. But that was the only time the judges found the fortitude. The rest of the time they stuck behind the paper trail And we had to wait 3, 4, 5 years to get hold of documents. Serbia rejected the implication of our assertion that they were not really being cooperative and said, oh, what bad luck it had been for Serbia, because it should be remembered, line 3 of what's in front of you, Mr. Djindjic, who was the Prime Minister, took responsibility for this act of surrendering Milosevic, and he, as some of you will remember, was assassinated. At the same time, from the investigation into this murder, it's transpired there's a further list of targeted officials, etc., etc. Well, frankly, bad luck. It's not that difficult to open the doors of your archive and let the investigators in, but it doesn't happen. Serbia sought to present itself further as being conscientious in its endeavours to create, by creation of something called the VJ Commission for Cooperation with the ICTY, the Yugoslavian Tribunal. We were aware of the existence of this commission since its foundation in 2002. We argued that it was actively assisting the defendants. It wasn't a cooperative body, it was a slanted body. We were right in what we said. That the matter was dealt with by some independents in a media commentary and analysis of this particular body. The Commission's disputed cooperation, that's the Serbian Commission of Cooperation, with Milosevic is a much bigger problem. Milosevic is posing very precise questions to witnesses which are based on very high quality information on battlefield events, the engagement of personnel and units and the political background of steps taken by the warring sides. Milosevic never named the source of his information, but the way his questions are posed indicate access to extensive information which only the army of Serbia and Montenegro has in a number of military sites. So, there we are. An external commentator says what they're doing is they're raiding their own material to slant, to bend these trials. And because they're a state, they're allowed to get away with it. In their own rules of procedure, this particular commission had as a let-out clause information that shows the state, no, not that one, that shows that a state or military secret shall not be provided to the Hague Tribunal, shall not be revealed if there are issues of state security. Let me move on from the generality, although it's in the printed version of this lecture, there's more detail there, and you can find some quite entertaining material if you find such things entertaining from a witness who said, well, we didn't have that document. No, we don't have that document. And then suddenly turns around when we said that, and we said, oh, that document, when we produced it to him, and of course it was a pretty deadly one. Things like that are funny if you're a lawyer, but they're not that funny if you're a victim. Because, of course, this part of the trial had the Milosevic case saying, tanks cleansing villages? Not at all. Our tanks were simply running around taking sweets to children at Sunday school outings, or the equivalent. And that's why we've got these documents that say as much, documents that this Commission of Cooperation had been busy writing in the intervening years, that the extended process of production allowed by the court permitted them to do. And it was particularly funny, again, if you find these things amusing, and some of you will have service experience. There were, of course, original maps for commanders to use, which showed what they'd been doing. It might not have said anything particularly incriminating, but they were the contemporaneous documents. This witness turned up with, and was allowed by the judges to turn up with, sort of colouring in plans, really. They look like very pretty, completely new plans that they'd drawn in the intervening years to try and describe what they'd been doing. There we are. The next issue is the Supreme Defence Council records. Now, these records have a greater significance, or the greatest significance, for reasons to which I'll come. I've referred to them and shown them to you once before in this series of lectures. They were the most important document collection the prosecution came to know of and to receive. We got them, the Supreme Defence Council, let's come through to it. Yeah, we'll make sense of that in a minute. The Supreme Defence Council succeeded the presidency of the Socialist Federal Republic of Yugoslavia, old Yugoslavia to many of us, that broke up. It consisted of Serbia and Montenegro and was known as the Federal Republic of Yugoslavia. And it did this body of Milosevic, a man called Bulatovic, who was president of Montenegro, and the federal president of this two-state federal entity. The body had the mandate of the commander-in-chief, and for us, trying to show what Serbia was doing in Bosnia or in Croatia, knowing what was being provided by this governing body was of crucial importance. Eventually, the SDC made their stenographic notes available to us. And aside, I learned a lot doing this trial. The first time I tried to get hold of these documents, I was on the phone to the lawyer, the very lawyer who we saw up there saying it's an adversarial process to get hold of documents from us. And I made the rather unfortunate mistake of treating him as if he might be an English lawyer. Oh, please give us the documents. You know you've got to give us the documents. Well, why don't you give us the documents? Well, that wasn't very successful, I can tell you. I put the phone down, and my colleague who comes from the Balkans gave me something of a lecture. When I recovered from the lecture, and the following week, I rang him up and I said, give us the documents. Give us the documents. Louder, give us the documents. You will give us the documents. Give us the documents. And it worked. How interesting it is to learn a little bit about negotiating with intransigent bodies. You just stick to your last and you don't move an inch. Still, that's another story. So we got these documents eventually, on the basis that only we could look at them. They couldn't be used in court. On that basis, we pressed for their production. We were always going to have them produced publicly, or not produced publicly, produced to the court to use, but Serbia, remember my proposition, always dead clever, knew what it was dealing with. By some stratagem, got the prosecutor to agree that the best bits of the documents would never be seen by the public. So that this is what the documents really look like, and these are the precise words, stenographically recorded, tape recorded, of Milosevic and all the others agreeing to how much help they were going to give the Bosnian Serbs. And so that looks like good copy, doesn't it? Unfortunately, that's what it looks like when it becomes interesting. And it goes on looking like that until it becomes boring again. So the information really wasn't very much use to the public. We could have it, but the public couldn't. Whether it was by chance or not, who knows? But Bosnia understood that it had to do something about Serbia. And what it did, being aware of the broader issues than just the trials of individuals, what it did was to bring a claim in the world's highest civil court, the International Court of Justice in The Hague, which normally deals with boundary disputes, law of the sea, all that sort of thing. It brought a claim there over a period of nearly a decade, alleging that Serbia had committed genocide against Bosnia. And for good or bad, people the victim of grave crimes that may qualify as genocide really want that matter to be dealt with. I didn't express a view personally on whether that's a good idea. That's what they want. Bizarrely, the International Court of Justice worked on the blacked out version. It didn't ask for the full version. The judgment came out in 2007, and I'm very grateful to Counsel for Bosnia, von van den Biesen, for providing me with these slides. Where we are. These slides, which explain something about the ICJ's judgment. It's a tantalizing judgment that went step by step towards, but stopped before, a finding of genocide or complicity in genocide. So no power to rule on alleged breaches of other obligations other than those that were charged, which were genocide.
The respondent was making its considerable military and financial support available to the Republic of Srpska, that's the Serbs in Bosnia. So it's beginning to look good. However, we require a further mental element, the intent to destroy in whole or part a group as such. The specific intent, great care must be taken in finding in the facts a sufficiently clear manifestation of that intention. The intent to destroy the group as such. In fact, in the context of the convention, said the court, the term ethnic cleansing has no legal significance, so we can sweep that aside. That won't do for genocide. Killings, it dealt with by saying that there had been conclusive evidence of lots of killings, but then it says, the court is, however, not convinced on the basis of the evidence before it that it has been conclusively established that the massive killings of members of the protected group were committed with the specific intent, the genocidal intent. May amount to war crimes, crimes against humanity, that's not for us, we can't deal with that. The court considers that it has been established by fully conclusive evidence that members of the protective groups were systematically victims of massive mistreatment and so on. So as people were hearing this judgment read out, they were feeling a measure of optimism, those represented by Mr. van den Biesen. The court finds that virtually all the incidents recounted by the applicant have been established by the available evidence. Still looking good. The court considers that there is persuasive and conclusive evidence that deportations, expulsions of members of the protected group occurred in Bosnia. Excellent. The court considers that there is conclusive evidence of the deliberate destruction of historical, cultural, and religious heritage. Still looking good. And indeed, it considers that there is persuasive, convincing, and persuasive evidence. Terrible conditions existed in the camps. These acts were acts of genocide committed by the Serbs, members of the Serbs in and around Srebrenica. Better still, but it has, however, not been shown that was any such participation in relation to the massacres committed at Srebrenica by Serbia. So it inched right the way up to the finding that Bosnia wanted and then held back. In the absence of evidence to the contrary, those officers must be taken to have received their orders from the Republic of Srpska. The Republic of Srpska is the Serbs in Bosnia, not the Serbs in Serbia, who we were pursuing, or who they were pursuing at the ICJ. The functions of the Bosnian Serb officers, including Mladic, were, however, to act on behalf of the Bosnian Serb authorities. Now, so we'll move on from that, I think, come to something else in a second. Can you see how important it was, or may have been, that Serbia, by its manipulation of evidence at court, was able to keep what was underneath the blacked out parts of those documents, but also all sorts of other bits of evidence, away from the court and away from the International Court of Justice? Result? Well, and again, I express no personal view as to whether this is a good or a bad thing, but the victims of Srebrenica can just about say they were the subjects of genocide because there had been verdicts returned against individual commanders in the Bosnian Serb force that reflect genocide, but they can't say our neighbor Serbia was actually committing genocide on us in order to carve out the new Serbian state, which is what they wanted to say. And they can't say it, possibly, because Serbia knew how to deal with controlling of evidence. What can Bosnia do now? It could seek to reopen the case. There is still time for that to happen. It could rely on further evidence that is now available. Many hope that might happen. However, the litigation history to date and any litigation narrative to come must acknowledge that courts can only act on the evidence available at the time of their judgment, and that they are indeed at the mercy of states when it comes to getting their hands on relevant documents. Finally, to Kosovo, a case study, not just in what can be achieved by a state within an actual trial, which is what we've been looking at, but can expose what mere exposure to investigation of those involved in these conflicts can offer a manipulative state. Kosovo was the beginning and the end of the Balkan Wars of the 1990s. Milosevic devoted a great deal of time, allowed him by the court,
to deal particularly with the Kosovo War. And he needed to make the Kosovo Albanians out to be as bad as he could in his own defense. There was, as I've explained already, active support for him at government levels in Serbia, as a minimum, when it came to cooperation or non-cooperation over documents. Did those bodies go further in trying to help him and in trying to set a record that might not have been entirely accurate? Well, for whatever reason, an allegation was made in 2003 to the tribunal's prosecutor during the Kosovo segment of the Milosevic trial that Kosovo Albanian leaders had, in the late 1990s, been organizing the execution of Serb prisoners in Albania, neighboring Albania, to harvest their internal organs for sale on the black market. The allegation, once it surfaced, and by the way, it had already been used earlier in the same conflict against other participating members of the conflict, or participants of the conflict, but once it surfaced, it was as improbable, you may think, for pretty obvious reasons, as the rumor started by Churchill in the war that the Russians ate their babies, which he did. I mean, he did start it, and once the Russians became our allies, he had to correct it. And he got a left-wing New Zealand QC, lovely bloke called John Platts Mills, and engaged him to go and get on and put the record right. In any case, the story was essentially improbable to the maximum degree possible. But it was being made not just against leading Kosovo Albanians, it was being made against their then current Prime Minister, Ramush Haradinaj. Now, papers have been leaked, this is the first one of them, in various forms to various news agencies, and show, and they are, this, for example, is an obviously genuine Yugoslav tribunal document, and it's associated with other internal reports of one kind or another, about which I'll say a little bit more in a second. Eventually, the whole of the very limited 32 pages of this investigation and report were made available without any redactions, without any bits blacked out. And you could see that on analysis there was nothing in the 2003 paperwork that justified the otherwise unsupported allegations of organ harvesting, and as a result the 2003 investigation came to nothing. Now, I should have known about this, but it was not brought to my attention, and in the office there was a very strong determination at the level of the chief prosecutor to have the Prime Minister, Ramush Haradinaj, charged and tried for war crimes. Indeed, he was eventually tried, and he was eventually acquitted. He was then eventually retried on very dubious grounds for precisely the same allegations and exonerated, acquitted again. That's another story, but it features. Haradinaj surrendered himself to The Hague immediately he was indicted, and of some significance to what follows, a man called Hasim Thaçi became Prime Minister. That chief prosecutor who'd been so keen to have the serving Prime Minister indicted left office, and she published a book in which these unsubstantiated allegations were raised again, but this time, and for no accountable reason, the focus of attention had moved from Haradinaj to the present, or the then present, no, he is still present, Prime Minister Hasim Thaçi. He barely featured in the documentation, but at the time this allegation was made, the documentation had not been leaked. Later, the Council of Europe became involved and launched an investigation which sought to find substance to back the allegations against Thaçi, the serving Prime Minister, and some say that the Council of Europe is dominated or heavily influenced by Russia, which is certainly an ally of Serbia. Now, Kosovo, as you will probably know, seeks practical confirmation of its independence, the independence it took from Serbia, and Serbia would no doubt like to discredit Kosovo in its application to become a full UN member, or indeed a member of the European family of states. The allegation in the Council of Europe was made by a former Swiss prosecutor called Marty. He'd been the subject of bruising encounters with European parliamentarians over the quality of the report he presented and the evidence on which he relied, which was the same evidence, years later, as had come to nothing in 2003. More interesting is that the first publication of his report coincided, the first leaked publication, coincided with an important European Council of Europe meeting. But at the first leaking of the documents, guess what happened? This is what they actually looked like. Oh, we've seen it before. Some interesting bits blacked out. And I think, is that as far as I got? Maybe that. Never mind, you've seen it. And there were lots of pages like that. And what do you think if you see something blacked out? Well, you think there could be something pretty serious behind here. And that's no doubt what was the intention, that the Council of Europe would think, Hasim Thaçi, bad boy, penalise the entire small state of Kosovo and don't let them do what they want to do. In fact, when you actually, another organisation later, published the whole version, there's nothing there. Nothing at all. So the redaction was with a pretty cynical purpose. And it was only later that the unblacked out documents appeared, when they could be seen to contain neither compelling evidence of the crimes nor any mention of Thaçi. There was no evidence of substance additional to what was first seen and rejected as inconsequential in 2003. One would think that full disclosure of these documents would have seen Thaçi exonerated, at least in the court of public opinion, in the way that his predecessor, Ramush Haradinaj, has been acquitted at court. Not at all. Further UN investigations, 10 years on, continue, and Thaçi, and to some degree his state, Kosovo, remain tethered by a rumour that would have got nowhere at all had it not been raised within the seeming solemnity and seriousness of a tribunal process. To date, not one piece of eyewitness testimony or forensic scientific evidence has been produced to support the organ harvesting, yet Thaçi finds himself forever tainted by the rumour and unable to prove the negative. The rumour and the lack of investigation into the origins of the rumour taint all Kosovo Albanians and play into the hands of those who are determined to see its claims for full statehood thwarted. Who raised the allegation? Little doubt. The same body that revives the allegation whenever it needs to in pursuit of its leaving a record of moral equivalence with the David that stood up to its Goliath. And if you think about that, and you think back to the list of nations I put up at the beginning, well, it would be politically incorrect to ask you. What out of all this? Nothing, if it is accepted that victory in conflict allows the victor to take all prizes, including the prize of setting the record. Nothing, if trials for conflicts are treated as conflicts themselves. Victors or vanquished should be allowed to do all they can, according to the rules of the game, to create whatever record they like. Where in earlier times trial processes were used by victorious states to achieve political objectives of pretty straightforward kinds, modern war crimes tribunals can actually be used by any involved in ways that can affect or corrupt the setting of a record of events, the very history of what happened. Now, if modern international trials are driven by objectives of long-term reconciliation, not just of victory in conflict, and if trials are being conducted according to concepts of human rights for victims as well as for perpetrators, then there are problems revealed here of which we need to be aware. What can Kosovo, or as I asked earlier, Bosnia, do to redress the imbalance they say harms them and will or may harm their future? 3 conclusions, perhaps, for us to think about. Those of us who read about these international trials can usually work on the basis that the lawyers and the judges are doing their best with the material available to them. But we would always be wise to keep in the backs of our minds that there may have been significant political manipulation of the material that has been made available. Second, those who established these courts, the United Nations and the states parties of the Permanent Court, the International Criminal Court, might have as a priority establishing systems that will allow documents to be obtained in hours or days, not in weeks, months, and years, and for documents obtained to be made public to the maximum extent possible as early as possible. For such a protocol would avoid the sort of problems we've had here. That may mean that the obtaining of documents, as well indeed as of witnesses, should be the active responsibility of the political party that establishes the court, the UN or the states parties, and that have the ability to sanction a country for non-compliance, because the ordinary prosecutors working in these tribunals have no powers to sanction. The most they can do is complain once a year to the Security Council, and nothing will probably happen because it's a political setting. And finally, and again this is a bit of a theme for my lectures this year, countries turning to courts to leave accurate records of conflicts should understand the limitations that court decisions inevitably involve. They should recognise that it is the responsibility of a country that has been in conflict to ensure that an adequate record is left of its own history, whether by truth commissions, by modern internet, computer-assisted evidence projects. And the countries must recognise that, or the countries concerned must recognise that if they don't take this responsibility, subsequent generations may hold them responsible for whatever may follow from their histories being inaccurately recorded. Thank you. I have time for a few questions if anybody wants to ask any, or comments if anybody wants to make them. Madam.
Where people are speaking different languages, do you think justice is ever lost in translation?
Do I think that justice is ever?
Lost in translation.
Absolutely. I think that the wonderful arrogance of mostly English-speaking nationals from here and across the Atlantic trying people through the filter of interpretation will be regarded as quite unacceptable. The problem, of course, is that to learn a language like, for example, the language of the former Yugoslavia, in order to be able to speak it with fluency is a hugely difficult task. And if you're going to become a lawyer working in that court, you won't have time to do it. So there's a problem. Do you say, as I would say, get as many locals involved, local lawyers and language speakers involved in the trials, not just for the reason of that you're saying, but for also all sorts of other cultural reasons. I think that's preferable, and I think these trials will be regarded as something of an arrogance in trying to do it in translation. So.
The issue about Serbia trying to obstruct proceedings, both the ICTY and the ICTY, I was curious your opinion on what seems to be the perception that Serbia has been successful in undertaking domestic tribunal or domestic proceedings with Serbian judges, Serbian prosecutors actually convicting Serbs. And I'm wondering your view of why that might be different. Why is there a sense that right now within Serbia there's an opening of a more objective approach to bringing to justice individuals, whereas on the international stage, as you stated, that just didn't exist?
Yes, I mean, national trials are always a good thing. I think all people involved in this line of work think it's better that they can be tried locally whenever possible, and the fact that Serbia is trying some people locally is either in itself a good thing and a sign of development within those ruling Serbia, or possibly something that they have to do if they are to achieve what they want to achieve in terms of being admitted to Europe and the UN. But the most interesting trial that I knew of in Serbia, which grew out of something that happened in the Yugoslavian tribunal, was to do with the 6 young men who were shown to be
executed by the Scorpions. Now, the Scorpions were a Serb group, and there was a terrible bit of film that I played, and then the whole film was played, and people suddenly realized that Serbia was in it. There was no way they could escape, because these men were connected by DNA to Srebrenica. They were boys, and Serbia controlled this group. Serbia had no choice but to try the people who were shown on the film killing these people, or the commander of that group. And they'd all been very conveniently filmed with wonderful mugshots so that we knew who they all were. But, and this is a very interesting and to me completely unexplained fact, who would you be interested in pursuing if you knew that a fairly low-level group of soldiers had committed a terrible atrocity? Who might you be interested in pursuing? Slightly tendentious question when I use low level. Well, you'd be interested in pursuing the higher level, the management chain, the ministers who sent this to happen. And two very strange things happened after we had that piece of videotape played. I tried to launch an investigation that would enable us to go further up the management chain in Serbia, and the investigation was blocked. In Serbia, they did try the people on the film. They didn't go anywhere else. So, shouldn't look for too many conspiracy theories, but it's a bit surprising. Anybody else? Yes, sir.
With your second conclusion, if I understood you correctly, you said that they should try to implement a system where there was more effective sanctions for not passing over documents. You also implied earlier on that the judges were not really using the power they already had. So to what extent do you think the judges, the rules that the judges already have could be used more effectively?
First of all, it's always terribly easy to do somebody else's job, and therefore it's easy for me to criticise the judges. I haven't sat in their seat and don't know how difficult it is. With that caveat, I don't see that it would have been. I mean, the rules are pretty detailed. You can get them in the print. No, they're not. You're not getting slides, but you can find the rules if you want to. They're pretty detailed, and they allow delay. But when the judges decided on this one occasion to say, produce that book tomorrow, it actually came at the end of the week, or maybe the beginning of the following week. And I simply don't know why they are content with this bureaucratic system. Because if you, in a national system, you hear that the LIBOR rate has been fixed and crimes are being committed, you're in the bank's offices this afternoon with a search warrant. Now, what's different from that? Well, what's different from that is that there's no police and there's no search warrant. And that's why it seems to me that the politicians should recognise the problems they place on the courts. And they should be firm in saying, in some way, if the court says to us, we want this document, we'll get it for them. I don't quite know the mechanism because we haven't tried it yet, but it should happen. And in these really important trials, I always thought, there should be somebody from Serbia, somebody from Croatia, in the court building. And if the judges decide at the end of the session, oh, actually, we'd like this document, go away and get it, why not? These trials cost a fortune. They take forever. And the best evidence is nearly always documentary. Documents can't lie. Well, they can lie, but not very easily. Human beings are quite good at it. That's it. That's your lot. Oh, one more question.
You said on an earlier occasion that the trials were not legal trials, but they were political trials.
Yeah.
And you also said that as far as Serbia is concerned, the bar is raised, whereas in Kosovo it is lowered.
Yes.
Is that still your...
You mean, raised in what sense did I say that? I don't know that those were my words.
You have to commit quite a heavy, heinous crime if you're a Serbian to get in, but if you're caught shoplifting in Kosovo, you're in the war.
Well, I think what it comes to is that there would seem to have been a policy that you're going to
prosecute people from all parts of a complex conflict. If you're going to do that, and the gravest crimes have been committed by Serbia, and some crimes, but of a less grave nature, have been committed by one of the other states, then you may land up trying less grave crimes here than serious crimes than here, because you can't try them all. And I think that probably did happen. And I don't think it matters, providing two things. First of all, that you have a residuary mechanism in the country concerned to sweep up all the trials that can't be dealt with in the International Tribunal. And second, that you're honest with the public, the international public, about the policy that you're pursuing. Right, I better go. Thank you very much.